Good morning, ladies and gentlemen. My name is Lok. I'm actually I'm an IP lawyer. So today I have 20 minutes to talk about IP considerations for website owners. You know, if you are you have already have a website, or you are planning to start a website to sell your product and services online, what are the IP considerations that you have to bear in mind? I'm from PINTAS IP Group. We are IP companies, and we are also partners of Exabyte. So I have 20 minutes to talk about the different IP that you need to be concerned about when you start your website or you plan to sell your products online, and also some of the best practices that you may want to bear in mind when you do your e-commerce on your website. First of all, a bit of introduction to intellectual properties. By the name itself, intellectual properties, you can know that whatever ideas or whatever creative content that you put on a website, they are all potentially a property that you can own if you register those ideas and creativities. Intellectual property is a form of intangible property, something you can't see, something you cannot touch, but it is something that gives a lot of value to your companies if it is properly protected. In fact, if you look at the books of some of the biggest internet companies in the world, like Google, like Amazon, I would say more than 99% of the value of the company lies in the intellectual property. So I have two sessions today. This morning I'll be talking more about the IP consideration for website owner. In the afternoon session, in the seminar, we will talk about the IP strategies for internet entrepreneur. So now my topic will be more concerned on as a website owner and you plan to sell your product and services online, what are the IP issues you should be aware of and you should take into considerations. So there are a few IPs that are of relevance to businesses. They are patents, trademarks for your brand, for your domain name. Patent is for your new product and services that you intend to offer online, or even if you adopt a new business model for your website, for your e-commerce business, then you may want to consider patenting those new business model. And of course, in today's world, you will be relying a lot on videos, a lot of e-books, a lot of content, to sell your product and services. And this is the domain of copyright. All these contents that you use for marketing are protected by copyright. And if in your website you come up with some creative shape and design, all these creative graphical user interfaces are actually protected by industrial design. So these are the 4 IPs that you have to be aware of. And if these new ideas and creativities are something that give a lot of competitive advantage to your business, then you should protect it at all costs. And there are certain things that you should be aware about IP. First, it is an intangible asset. And secondly, it gives the owner a monopoly right over your ideas and creativity. So if you come up with a new brand, or if you come up with a new business model, and you protect them as, you protect those innovation or idea as IP, then you have the monopoly over it. So if your competitor were to come and use your content or use your brand, then you have the right to go after them. So it's a monopoly right. So registration is something that you need to do to turn these ideas and creativity into your own asset and properties. And there's another characteristic that is that you have to be aware of. Intellectual property is a jurisdictional right. It is granted, the monopoly right is granted to you by the government of the land. Yeah, it's a monopoly, it's an intangible rights. So if you want to own your IP, you need to register it in your key market. Yeah, so this is a challenge for website owner, for internet entrepreneur, because internet, as you know, is borderless, but IP right is jurisdictional, meaning if you have this domain name registered in Malaysia, it covers Malaysia. So there are certain international conventions that you can look at for you to register your IP worldwide. So be aware of that. Yeah. So I believe when you do e-commerce, you are targeting the world. So you need to consider registering your IP worldwide. And lastly, IP has a lifespan. Like for example, patent is for 20 years, trademark is for 10 years. So you have to make sure that you renew those IP to make it enforceable and valid. A bit of introduction, yeah. If you are selling certain innovative product, or you have a unique business model for you to deliver your goods and services online, then you may want to patent that innovation in your business model or the products that you want to sell. There are different types of patentable invention. You know, when you talk about patent, what you are actually owning is actually innovation that solve a problem. A simple product like, you know, if you sell paper and glue combination is something that you can own as a patent. In patent, what we own is a combination. We are looking at, you come up with a new combination, you can patent the combination. So the various patentable invention, it can cover article patent, it can be a machine patent, it can be a process patent when you do a new business model online. Like for example, the one-click by Amazon.com is a patented process, right? So Amazon.com actually rode on that technology for the past 20 years and become one of the biggest players in e-commerce. Yeah, when you do clicking to order something, and that with a one-click action you order, you complete a transaction. This one-click process was actually patented. So if you are innovative enough, you come up with a new way of actually doing a business model online, potentially you can file a patent for that. And with that, if you can own that combination, no one else can use the same combination to compete with you. Yep, so these are the different technologies that you can patent. The other very important IP that every website owner should be aware about is trademark. Yeah, as you see, all these are very famous brand owned by all the giants of the internet world. And I think the most basic protection that you should do is to own or trademark your domain name. Because, you know, if you don't, domain name is actually the gateway to your company, right? Nowadays, everyone will use internet to access, to find out about your services and your products. So it is important that the domain name are registered as a trademark. For e-commerce, for website owner, another very important IP is copyright. Copyright protects how you express, how you tell your story. So there are different ways where you can express your ideas. One of the way to express your ideas is probably, you know, you take a video about your product and services and put it online. So this video content or the ebook content or the photograph that you use in your e-commerce, all these are protected by copyright. And also your source code, you know, when you want to come up with a system, your website, coding behind your website, these are all protected by copyright. So it is important that, you know, you own the copyright. But having said that, copyright is something that exists automatically. Yeah, you have to be aware that if you come up with a book, you come up with a source code, or you take a video, or you shoot a photograph, the copyright automatically exists. There's no registration requirement for copyright. So in order to prove copyright, you know, if there's any infringement, you need to prove copyright, then you use a statutory declaration, yeah, to declare that you are the owner. This is how you own a copyright, by statutory declaration. And because there's no requirement for registration of copyright, every content that you can find online are all copyrighted. So you have to be very careful, right? When you use any content posted by any other party online, you have to be extremely careful. It is owned by someone. So you have to get certain clearance before you use any third-party content. Okay, so copyright is, I would say, the basis of your, the basis protection, the basic protection for your website. And of course, the other types of IP that you have to be aware of is industrial design. Industrial design protects that graphical GUI, the GUI interface. Sorry, I didn't notice. Yeah, sorry for the interruption. So industrial design protects the shape, the design, the outlook of your website. So in summary, if you are a website owner, your website is protected by different types of IPs. So if you have some technology behind your e-commerce engine, for example, a new way of delivering services, a search technology, a payment gateway technology. Nowadays, increasingly, blockchain technology is getting more and more popular. So you are using some new technology to deliver your services or content online. The business model, the technological portion of it, you may want to patent it. In fact, if you are an internet entrepreneur, you should consider patenting your web-based business model. Yeah, this is something you should look at. Next, you should look at copyright. All your content, nowadays, you know, content is so important. You have to put up a lot of content in the form of videos, ebooks, photograph, write-up. All these contents are automatically protected by copyright. Yep. So make sure you put the proper notice on all your content to indicate to the world that you are the owner of those copyright. And trademark, again, is important. If you have a domain name, you have certain brand to brand your services, online services, like AdWords for Google, right, for example. Those words, those brands are very important, which you need to trademark in your relevant market. Industrial design protects the shapes, you know, the graphical user interface. And a lot of your content on your website are actually secrets. So a step must be taken to safeguard the secret. You don't give everything away. Yeah. So you may have certain user agreement in your website for people to you have to commit them before you share some of your secret with your user. So these are the IPs that allows you to own some of your content and creativity. And of course, on top of the IP, there are other ways that you can protect your trade secrets and your content. As I mentioned just now, your website may contain a lot of trade secrets, so you may want to put up certain online agreement to give the visitor only limited rights to use those content, right? So it's important that you have a certain online agreement in place for them to agree to before you allow access. Sometimes some of your secrets, software products, audio visual work might be protected by some encryptions or password. Before you grant access, you want to know who are the user, who are accessing your website. And of course, the conditional access system, you don't want to open up your content to every visitor. Your competitor might be one of those who actively, look at your website to find out more about your pricing, more about your business model. So you may have want to have some access control. And as a rule, also you may want to put some fingerprint. Fingerprint is digital, fingerprint in some of your content, so that if one of your competitors were to copy your content and use it for their own use, and you may want to go after them, then you would have all this fingerprint to prove that this is already originating from you. So these are the different content access control that you want to have. And at this juncture also, I would like to raise the issue of ownership, because internet world is borderless. It's anyone can come and access your website. Then you have to be aware about the ownership issue. First of all, when you do your own website, the question is who owns the IP of your website? Who owns the pictures? Who owns the ebook that you create? So under the law, if you engage an independent contractor to develop a website for you, and if you don't have anything black and white to say that you own the IP, you own the copyright, then the contractor, the independent contractor, will own it. This is the default position. Yeah, you get someone to develop a website, to design some videos for you, or to create some ebook for you, and there's nothing black and white to say that you are the owner. Even though you pay money, the copyright, the IP may belong to the third-party contractor. So you have to be aware, right? You have to make sure that whatever you pay for, you own it. So this is something you have to bear in mind. It is advisable for you to enter into some black and white agreement with your independent contractor when you develop your website, when you create content. This is something you have to be aware of, because if you don't do it, whatever you create, even though you pay for it, it can be used by someone else. Yeah, this is the first thing you need to be aware of. And also questions about, can you use IP owned by others in your website? Yeah, as I mentioned, copyright is automatic. There's so much copyrighted work out there. So are you allowed, to take a photograph, to take a artwork, a drawing from the internet and paste it on your website? The answer is no, because all these the copyright is owned by someone else. Basically, every content that you take from the internet, you need to have the permission of the copyright owner. Otherwise, you may get sued for using those materials. Yeah, so using third parties' content, you have to be careful. And sometimes, when you take photograph, you have to be aware that you may take a photograph, you get the owner consent, but on top of the owner's consent, the person who take the photograph is the owner of the copyright. So you may need the consent of that person who take the photograph, and also the subject of your photograph. You may have to get some consent. Let's say I see that this girl is pretty. I take a photograph of him or her. So this type of consent is something that you have to be aware of. If you take a photograph of a person, the person depicted in the photograph, you may have to get her consent or his consent. You take photograph of copyrighted artwork, the clearance might have to come from the artist. This is something that you have to be aware of when you use third parties' copyright. Trademark is another potential potential area of dispute. Like for example, you may use your competitor's brand and you discuss it on your forum or discuss it on your website. So you must use it in such a way that you don't create confusion, that you are actually using the trademark as an indication of origin, right? It's okay to discuss third party's trademark, but not using it to create confusion as to the source. It's very important, okay? And there are also issues when you do meta tagging, linking, framing. Like for example, when you do meta tag, you might, like you are selling chocolate and you use Cadbury in your meta tag. So people check Cadbury may come to your website, and that is also considered an infringement. So you have to be careful about that. You are using e-commerce system, search engine and all that, you may use some plugin. You of course need a consent, because all these, the IPs are owned by third parties. So these are the things that you have to be aware of, right, when you want to develop your website and you want to use a third party consent. And I don't think I have much time left. I end with a slide about, if you are engaging a third party to develop your website, develop your content for you, then in that agreement, that you have to specify issues relating to ownership, right? Who owns the services or the products that you want to develop, or the website you want to develop. Warranties by the service providers, that the ownership, there's no infringement of others' IPs, confidentiality, and also liabilities, responsibility. If there's any infringement, who will be liable? So these are the issues that you need to consider. So to sum up, my today's presentation, we talk about your web. When you develop a website, you have your own content, you have your own innovation in your website. You need to protect it, and at the same time, if you develop your website and you engage a third party, there are also the third party's IP that you have to be aware of. And it is advisable that you look at both IP from both angles. So I think with that, I come to the end. I may have 5 minutes of Q&A, or 5 minutes of Q&A. Any questions that you want to ask? Yes, please.
Hello, my name is Rizwan. Okay, my question is that if we hire a freelance designer to design our logo, okay, can it, and then we register for IP without any kind of agreement that say that the IP things. So can it be contested later by that freelance designer that it is his or her design?
Yeah, I see. In default, the legal position is if I engage a third party, not employee. Employee's work will belongs to the employer. But if I have a third party contractor developing anything for me, be it a logo, a content, a video, or a website, by default they own it. So it's better to put in black and white that you own it. Yeah. Because there's a lot of dispute arising from this. Someone engaged an independent contractor to develop some content, and later on the content was also licensed to other competitors. So this happens quite a lot. So you have to be aware that black and white, there has to be an agreement as to the ownership of IP. Okay? So especially when it's not from your employees. Yes, please.
Everything that was mentioned just now is also applicable to.
Yeah, of course. When I talk about website, I'm talking also about mobile apps. They are all considered in the web space. Yeah. Okay, the gentleman first.
you know, when we engage developers to develop whether it's an app or a website, so we always these days we do something called an NDA, non-disclosure agreement, right? And in the NDA we also put non-competitive. You can't reproduce this similar site for other clients or steal ideas. You know, how effective is that, and to what extent we can use that, if at all we are breached in that?
And NDA, I think, is a must because, you know, when you engage a third-party contractor, you will be divulging a lot of your secret, right? So NDA is something so basic. They have to agree not to share your confidential information with third parties. But NDA does not address issues like ownership. It's only about confidentiality. So on top of the confidentiality, you also might want to add clauses like what I mentioned just now, the ownership, about warranty, you know, whatever pictures, whatever coding that you use on my website does not infringe others people's IP. You know, you don't want a situation where they take coding from the previous work and then put into your website, and now you're also infringing the previous owner's IP. Or photograph. Nowadays, all photographs are owned by someone, right? You will buy from certain image bank, you know. When we buy image bank, you actually pay a copyright to the owner of the copyright. So all this issue has to be looked into for you to create your own web presence. Yep.
Hi, my name is Ben. My question is, when we sell into marketplaces, normally they will ask us to grant a royalty-free images for all the artwork, the videos and the images that we uploaded to those platforms like Lazada, Amazon. Are we able to protect our rights after we uploaded those images to those platforms?
Oh, you mean Lazada will want you to assign all your copyright?
Yes, grant them royalty-free.
Oh, okay.
That's the words they use.
Royalty-free, okay.
Yes, yes.
Yeah.
Because after we upload it to those marketplaces, and there's a potential that those images and videos could be used by someone else. That's the question.
Yeah, so royalty-free to the platform owner, right? To use, but not to sub-license, isn't it? They can't allow a third party to recycle your photograph or video, but they can actually use it for their own limited royalty, limited license to use it for their own marketing purpose, isn't it? So there is a limit to the license, you know. It's not to assign the ownership of your copyright to the platform owner. I don't think they will go to that extent, but sometimes they may use some of your photograph for their own marketing promotion. I think that's fine, right? Yeah, yeah. So, but having said that, all the platform owners are so powerful. You can't tell, you know, Alibaba that I don't agree with this clause. So, you know, it's a one-sided kind of a situation. Yeah, so I think it's limited license for them to use it for their marketing purpose only, but not to re-license it to a third party. I think time's up for me. Thank you for your attention. And this afternoon, there will be a session on the IP strategy for internet entrepreneur. If you're interested, we can meet again. Thank you.